Okay, court will come to order. Mr. Baez, who is the defense's next witness?
Richard Eikelenboom.
Okay. I have reviewed the requested instruction that the state has proposed, and I've reviewed the instruction that the defense has proposed. Now, did Dr. Eikelenboom provide a partial report?
No, Your Honor.
He provided an affidavit, and he, in deposition, referred to it by that term as an affidavit. It does not. I provided the court with a copy of it the other day, and
well, this is what I'm looking at. It says affidavit R. Eikelenboom dated January 21st, 2011. Is this what he provided?
yes, Your Honor, that's the item was provided
Okay.
through defense counsel.
This is the instruction I propose to give. All expert witnesses were required by order of the court to provide reports of their findings by providing 1, a complete statement of their opinions, 2, the reason for those opinions or conclusion, and 3, any data or other information considered by the witness informing their opinion or conclusions. These reports were due at a time prior to the trial of this cause. The report of this witness was not provided to the state of Florida until Saturday, June 18th, 2011. You may consider this fact in judging the credibility of the witness's testimony. Mr. Baez?
Yes, sir. We maintain our objections since I have withdrawn the areas that were previously at issue. We would just, for the record, object.
Okay. Before I do that, I need to have the witness come in, and I need to make an inquiry of the witness, and then I need, before I formally impose the sanction, I need to make a 3-prong finding for purposes of the record. So let's have the witness come in. I have a few questions I need to ask him. I will file, this first item is the defense's proposed instruction, if I was going to give an instruction. The second item is the state's handwritten requested instruction.
You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
My name is Richard Eikelenboom, Eikelenboom, Eikelenboom.
Doctor, I'm Belvin Perry. I'm the presiding judge in this case. When were you first retained by the defense?
The first investigation was, or the first request, official request, for the case was when we had to look over the evidence.
And when was that, sir?
That was on 13 July 2010. And of course, it was a couple of days before that.
July 2010.
Yes.
Sir, were you ever informed that you were required to produce a report outlining the opinions that you rendered in this case as a result of your examination of the evidence?
Except for the affidavit, I was not told that I had to render opinions or write another report.
Sir, were you ever informed of the following? Where expert witnesses have not prepared reports of examinations or tests, both the state and the defense are required to provide the following information, which shall be filed with the clerk of the court in form of a written pleading. 1, the expert's curriculum vitae or qualifications of the expert. 2, the expert's field of expertise or medical specialty. 3, a statement of the specific subjects upon which the expert will testify and offer opinions. 4, the substance of the facts which the expert is expected to testify. And 5, a summary of the expert's opinion and grounds for each opinion. Were you ever informed of that order of the court?
No, I don't recall that order.
Okay. I take it, sir, that you do not live in the continental United States?
Well, actually, since February, we're living in Conifer. But before that, we were living in the Netherlands.
Okay. How were you communicating with the defense? Was it by phone, email, or by what other means?
By phone, email, and Skype.
Okay. Were you ever requested or asked between December 2010 and May 1st of 2011 to reduce your opinions and findings in writing in a report format as I've just outlined?
Sorry, reduce? I mean, to write a report?
To write a report in the format that I've just outlined, sir.
No, I don't recall that.
Okay. Who was the principal person that you communicated with for the defense? Who were you getting your instructions from?
Mr. Baez. And we also had communication with Michelle.
Okay. Now, from May of 2011 up until today's date, were you ever asked to reduce your report in the written format that I've just outlined, which would include all of your opinions that you were asked to produce?
Last Saturday, I talked with Mr. Baez, and then after we went to the district attorney's office to do the deposition where we were refused, I was requested that I would write a report. So last Saturday night, we wrote a short report.
Between December 1st in the year 2010 up until May 1st, 2011, how many times have you communicated with members of the defense team?
Well, I'm not completely sure about that. I know we had communication short before we had to do the inspection of the evidence, and short after. And then for a long time, I didn't hear anything anymore. So we more or less lost contact and lost track of the case.
From December 1st, 2010 up until May 1st, 2011, were you readily available to be contacted by the defense team via email, telephone, or Skype?
Yes, the defense could reach us if they wanted. Yes.
You didn't disappear during that time period, did you, sir?
No.
Okay. Either the state or the defense want to ask any questions along those lines that I've just asked.
Yes, sir.
You may proceed.
Mr. Eikelenboom, is this the first time anyone has ordered you to write a report on a case?
To write a report on a case?
No, not on a case, on that had certain parameters like this one.
No, in the Dutch courts, yeah, you sometimes get a request, and that's by an investigative judge, and they can order you to investigate certain evidence or certain reports, or and write an opinion about these items.
And that would be based on things you've done, correct? Like run certain samples of DNA, inspected certain pieces of evidence.
Can be both. Can be on investigations which we have performed, but can also be on investigations of other laboratories, and then they want a second opinion about the methods used or conclusions drawn in those reports.
Okay. And the contact with your company back in January of 2011, that was done through your wife and Miss Medina, was it not?
Yes.
It wasn't
correct.
directly with you.
No.
Okay. And in fact, what occurred and how this order was, the information got back to you came originally from Miss Medina to your wife and from your wife to you.
That's correct.
Objection assumes a fact, not an evidence, that the information about the order ever got to the witness. He's indicated it didn't.
I permit him to go ahead. Objection overruled.
Okay. Now, what you ended up doing is based on what your wife ended up telling you, correct?
Yes, you're talking about a very short affidavit.
Yes, the affidavit. Okay. And what you in turn ended up doing was filling out an affidavit of all the work that you had done up until this point, correct?
Yes, this is more or less about the evidence viewing.
Which was you wanted to inspect a piece of evidence for your own testing, but it was denied, correct?
Yes.
And then also that you had actually gone and done an inspection of the evidence, correct? And took photographs.
That's correct.
Okay. Were you ever told in any way, shape, or form to narrow your report or to exclude things from your report?
No.
Okay. And the report or affidavit that you ended up submitting was based on what you thought was required of us.
Yes.
And you never spoke directly with Miss Medina about what the court has actually ordered.
No.
That conversation actually took place with your wife and Miss Medina, correct?
That's correct.
And then later on spoken to you, correct?
That's correct.
Do you recall exactly what your wife told you was required by the court? If you can remember.
No, I don't recall that.
Do you remember that conversation at all, only that maybe it happened?
No, I don't remember the conversation at all. And the affidavit, yeah, I remember something about the affidavit, but we were very busy in that time. We were in the transfer time that we transferred from the Holland to the United States. So I didn't think much about this affidavit.
And the questions and the opinions that you raised and formulated on Saturday, they were first broached on Saturday, correct?
Yeah, when we were talking about the case on Saturday afternoon after the court session, then the idea came up to write a report or to form ideas about what topics you were talking about.
And these are not opinions that you held before and had discussed with us previously, and we determined that you were going to testify about these opinions prior to Saturday, and you just didn't not include them in your report, correct?
That's correct. On Friday, I made a PowerPoint presentation and just an average presentation for explaining contact DNA.
And Friday's PowerPoint presentation was just a general explanation of touch DNA and nothing more.
Yeah, and how PCR works.
They weren't specific as to any of the issues that were raised in this case, only an attempt to explain touch DNA.
Yes.
Okay. And upon our conversation on Saturday, you were then immediately asked if you would consider taking a deposition at the state attorney's office to now discuss these new opinions.
Yes, so during the lunch,
Yes.
we discussed the topics, and then about which I might be allowed to talk during court. And then we had an appointment with the district attorney's office to do deposit.
Okay. And what happened when you showed up at the state attorney's office?
We were refused entrance
By who?
by the district attorney.
Who? Is he sitting here?
Yes.
I'll stipulate it was me.
Okay.
That'll help.
And what exactly did he say?
I don't recall exactly what he said, but as I understand it, I was at least not going to do a deposition.
Was he polite?
That sounded kind of rude.
Okay. And after that occurred, were you then instructed by Ms. Medina to immediately do a report?
Yes.
And you did that?
Yes,
And then you emailed that to me Saturday night?
that's correct.
Okay. I have no further questions.
Mr. Ashton, any questions?
May I just do it from here, Your Honor?
You may.
Is there any opinion that you have expressed in your Saturday afternoon report that you could not have developed 4 months ago through the same conversation with Mr. Baez?
Well, depends on the information which was available at that time, but like DNA reports, that probably could have been, if asked, I could have written a report about that.
Did he give you any new information during, and you spoke at lunch on Saturday,
Yes.
correct? Did he give you any new information during lunch on Saturday that you had not been provided with before?
Well, for me, it was new information because I didn't follow the case. So the case, when we left, we got a subpoena a week ago, or it's almost 2 weeks ago now. So the case for me was not really clear, and I know, of course, about the case, but I really didn't follow it. So for me, maybe the information was there, but for me, the information was not clear, and it was not clear which direction everything was going. So I needed that guidance during the lunch.
I understand you may have got new information about what Mr. Baez was interested in, but did he give you any new reports, any new factual information that you didn't have already?
I got, I think that was during Friday and Saturday. We got new information, so about crime scene pictures and some extra reports.
What new information?
Reports from the FBI and some extra pictures.
So you hadn't had the FBI reports before Friday?
Not all of them, no.
What new ones were you given? What new FBI reports were you given on Friday?
Oh, I just, actually I got the whole folder, so.
Well, can you give us any more guidance on what you had already and what you got that's new?
I've seen reports before. That was, I think that was during the investigation of the evidence. So I form an opinion about the case, and I know something about what was already then. And during last week, I requested for more information, digital, and I got all the reports, which were then, that's a lot of reports, of course.
And you made that request after you got the subpoena and realized that they were actually going to want you to testify?
Yes.
No further questions.
Okay. Pursuant to Richardson versus State 246 7 seconds 771, a 1971 decision of the Florida Supreme Court, as amplified in McDuffie versus State 977 second 312, a 2007 decision of the Florida Supreme Court. The court will make the following finding of fact. 1, whether the discovery violation was willful or whether or not it was inadvertent. On December 10th, 2010, the court entered an order. The order was entitled Order Granting State's Motion for Clarification / to compel compliance with order for additional discovery. On December 1st, 2010, the state filed a motion to clarify. At a subsequent hearing, it was determined that there was some dispute concerning a prior order that the court had entered and the intent of certain language. The exact language of that court order at the time provided as follows. The defendant shall also provide to the state a list of the defendant's experts that shall include the subject matter as to what the expert would testify to and the area of expertise for each expert. The court goes on to say there was some debate about the word subject matter rather than substance. The court said while the order included the term subject matter rather than substance, the court finds that the list provided by the defense does not comply with the intent of the order or the intent of the court as expressed in its November 29, 2010 hearing. In order to clarify this issue, the court went on to order the following. Where experts have not prepared reports of examination or tests, both the state and the defense are required to provide the following information, which I have previously outlined. The court at that time thought that the matter was clear. In January, the court was back again to deal with this issue again. Going back to the December 10th order of 2010, the court specifically provided, with respect to all other experts, this information is to be provided by 3 p.m. on Thursday, December 23rd, 2010. There were some different deadlines with respect to Dr. Fairgrave and Dr. Bach. That information was to be provided by December 14th, 2010. Again, we had the same problem again, and the court again specified what information and reaffirmed its prior order and assessed sanctions. The obligation are for the attorneys to see that their witnesses comply with the orders of the courts. It is the attorney's job, be it the assistant state attorneys or defense counsel, to make sure that their expert witnesses comply with the order of the court. The court will find that this violation is not inadvertent, that it should have been clearly communicated to the expert, and that the expert should have been required to comply, and the expert was not. Therefore, the court finds that the discovery violation was willful and not inadvertent. The next issue is whether or not it was trivial or substantial. DNA, even though the advent of DNA evidence has been around for a number of years, certain opinions that will be expressed by this witness as a result of the deposition, which is now on file, cannot be viewed as trivial when we start talking about rendering opinions with the of analyzing decomposition fluid in a trunk. So the court finds that it is not trivial but substantial. The next issue is whether or not it had a prejudicial effect on the opposing party in the preparation of their particular case. The court has delayed the testimony of this witness in order to give the state of Florida an opportunity to take this witness's deposition. If the witness had authored a report, put his opinions, the basis for his opinions, and the data which he relied upon with those opinions, then this court would not have given the state an opportunity to take his deposition because they chose not to do it. If those items would have been in his reports, then the state would not have had the opportunity. The question comes in as to whether or not I need to totally exclude his opinion about the possibility of a DNA analysis which may have some Fry implications, and this court cannot, in this short period of time, make that particular determination. All of the cases indicate that the exclusion totally of testimony is an extreme remedy to be utilized in rare circumstances. The court has decided to do the following. At this juncture in time, the court will not permit the witness to testify on this particular issue dealing with the possibility of a DNA analysis on the decomposition of fluid in the trunk of the car. The court will give the defense until next week by Saturday to file whatever potential motion it wants to lay out for a Fry hearing. And the court then on Wednesday evening or Thursday evening at the conclusion of the day's testimony, after a 1 hour break to give the attorneys an opportunity to get something to eat, then we will come back and conduct whatever Fry hearing we would need to see whether or not this testimony does meet Fry, or whether or not there is even a Fry issue involved in that particular testimony. That should give each side ample opportunity to do what they need to do. And it is a remedy short of exclusion, but I will not permit this testimony at this particular time. Anything else on behalf of the defense or the state?
Not on this issue.
Okay.
I have a brief issue that I'd like to bring to the court's attention.
Yes, sir.
Today, we were handed by the state of Florida discovery, which concluded 2 compact discs.
Okay, we'll take that up at noon
Yes,
on
sir.
your lunch hour.
Yes, sir.
But we got a jury that's sitting in there.
May I just make sure?
Yes, sir. Yeah.
And I want to also make sure that he's removed from the PowerPoint any issue, anything related to the issue about DNA from decomp fluid needs to be removed from the PowerPoint.
I believe we're ready, Judge.
Okay. All right, let's return to jury.
All rise for the jury.
Okay, Madam Clerk, may you swear the witness, please?
Swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God.
I do.
Okay, ladies and gentlemen of the jury, let me give you the following instructions. All expert witnesses were required by order of the court to provide reports of their findings by providing 1, a complete statement of their opinions, 2, the reasons for those opinions or conclusions, and 3, any data or other information considered by the witness informing their opinions or conclusions. These reports were due at a time prior to the trial of this cause. The report of this witness was not provided to the state of Florida until Saturday, June 18th, 2011. You may consider this fact in judging the credibility of the witness's testimony. You may proceed.
May it please the court? Mr. Ashton. Good morning, ladies and gentlemen. Good morning, Mr. Eikelenboom.
Morning.
Actually, can you state your name for the record
Richard Eikelenboom.
and introduce yourself to the ladies and gentlemen of the jury? Sir, what is your profession?
I'm a DNA scientist.
Okay, and you have an accent. Where are you from?
Oh, I'm from the Netherlands, so I apologize for my accent.
Now, can you give the ladies and gentlemen of the jury a little bit of your educational background? Can you explain that to them?
Yes, I started working for the national lab in the Netherlands, which is at that time was the only laboratory doing all the homicide and crime cases for the Netherlands. In early 90s, and I started on the Department of Serology. The Department of Serology later became Department of Biology, because in the early 90s in the Netherlands we also started with DNA. So I started on the serology department doing protein electrophoresis and blood group typing, which is the front runner for DNA. So later on, I became more involved in trace recovery, so finding the stains.
What does trace recovery mean?
Trace recovery, well, actually for the biology department, is finding all kinds of biological cell material which could be used for either electrophoresis at the time in the beginning and later on could be used for DNA profiling.
And have you had any other training on DNA?
Yeah, I went to laboratory school first. That was analytical chemistry, so that was not really in the field of biochemistry. And then during my working for the National Laboratory, I followed an education on biochemistry.
Okay.
And that means biochemistry, you work with DNA and you try to decipher DNA. So it's all involving decipher DNA. So it's all about DNA.
Okay. Now, I'd like for you to speak as close to the microphone as possible so everyone can hear you a bit clearer. Now, how long have you been working as a DNA scientist?
Around 20 years now.
Okay. And how long did you work for, was it the Federal Police Department of the Netherlands, or?
No, the Netherlands Forensic Institute is under the Justice Department. Our system is a little bit different from the United States. So I was working for the Justice Department for around 13 years.
Okay. And after that, where did you work?
In 2005 or 2003, my wife started the company Independent Forensic Services, and I joined the company in 2005.
Were you ordered to do that?
No.
Okay. Now, sir, can you explain to the ladies and gentlemen of the jury what the difference is between regular DNA and low copy number DNA?
Objection, Your Honor. The witness has not been qualified as yet, and I have a word-iron question.
Okay. Then Mr.
I'll
Flounder.
pass over for her qualification for the voir dire, and then I'll continue. Okay, Michael, take that stuff. Let's go take a cup.
Mr. Eikelenboom, the highest degree that you have obtained is what's referred to as an engineer's degree in Holland. Is that correct?
That's correct.
And that engineer's degree is something between a bachelor's degree, but not quite up to a master's degree, somewhere in between those two, correct?
That's what you could say, yes.
Approximately. Your degree is in biochemistry, correct?
That's correct.
And your specialization for your degree in biochemistry was in the study of luminol, correct?
That's correct.
That's a substance that is that lights up to show where blood is, correct?
Yes, it reacts with oxidized metals.
Okay.
But it is used, in CSI a lot for finding bloodstains.
But you did not specialize in molecular biology or DNA in your biochemistry degree. That was not your area of specialization, correct?
That's not correct. Of course, the biochemistry education has biology, all kinds of fields and training in DNA and biochemistry. And then as a part of the last year where you do an internship, which of course was at my work, then I choose for a luminol subject. So that subject didn't contain much DNA. Of course, we were finding out, so actually it did contain quite a lot of DNA. What we tried to find is to make a new solution of luminol, which would not deteriorate DNA. So it had for sure something to do with DNA.
Now, when you were working at the same time you were in school, you were also working for the Netherlands Forensic Institute, Department of Biology. But you did not do DNA testing for that institution, did you?
I worked on the biology department, and the biology department is divided in sections. And during the time we're talking about my training, I became a coordinator, and that means that you coordinate cases, you get all DNA results, but it's all on paper, and I had you can have an accent on certain investigations. That could be DNA extraction, that could be analysis. My emphasis was on trace recovery.
Not DNA analysis or extraction?
No.
And in fact, though you had some training in DNA with the laboratory, you were not certified by that laboratory to perform DNA analysis, were you?
That's correct.
You did trace recovery.
Yeah, as an accent, and I coordinated cases and reported cases.
Coordinating cases means basically deciding which unit should get it first, how best to coordinate the various disciplines in examining an item. That's what you mean, correct?
And then you get all the results. So you have to know something about DNA in order to do interpretation. So analysis in the sense you get the results, but you do the final comparison about suspect, victims, match or no match.
But you didn't actually perform, analyze, or interpret DNA cases during your period of time with that institution, correct?
I did a lot of interpretation. I did not do the performing the actual pipetting of extraction or analysis in the unit analysis. But
I see. But in 2005, your wife and you opened a business
correct,
called Independent Forensic Services.
correct,
And you and your wife appointed you as, quote, director of DNA.
correct.
No further questions, Your Honor. We would object to his qualifications as an expert in this area.
I have more that I'd like to elicit from him.
Go ahead.
How many cases did you work where you actually recovered DNA and processed it in the Netherlands?
In the Netherlands.
Yes.
Processed the DNA cases, so that was during Independent Forensic Services.
Correct. Prior to opening up independent forensic services.
Prior to.
Yes, yes.
So what I said for the Netherlands Forensic Institute, I worked on, as a coordinator, I worked on a lot of high profile cases, but then as coordinator, you get the results from the laboratory technicians. During the time with Independent Forensic Services, we started doing everything ourselves. We didn't have lab techs. So in that time, we did from trace recovery till the report writing and court testimony all ourselves.
And did you receive any training on how to do these, how to do both the trace recovery, extraction, and PCR process, and everything else that is required when running a DNA sample?
Yes, of course. We had during the biochemistry lessons, you get to know the DNA extraction. And in the Netherlands Forensic Institute, I followed all courses which were aligned to become an expert witness there.
Okay. And was your lab, Independent Forensic Services, accredited by any organizations?
Yes.
Which organizations?
In Holland, we have a Dutch accreditation board, and that is similar to what you have over here as the ESCLET accreditation. That's a board which accredited DNA laboratory or for all kinds of laboratory, but in this case, DNA laboratories.
And do they require certain proficiency testing?
That's correct.
Okay. And what is proficiency testing?
With proficiency testing, you get a blind sample, and in this case, or in our case, we used CTS because we know that's an American-based company, collective laboratory testing. And they send out a sample or more samples, reference samples, and as a crime sample. And then the laboratory has to perform DNA on that and then send back the results without knowing whether or not they were right. And after you send that in, a couple of months later, you get results back and you can see whether or not your test has been performed well according to 160 or more laboratories which were participating in that test. And till now, we always met the criteria of the other laboratories.
And have you, has your laboratory been contracted by law enforcement from your country to
That's
do
correct.
DNA samples?
Yes.
How many times?
Over 100 times.
Okay. And in addition to that, have you ever been asked to testify as an expert witness in the area of DNA analysis?
That's correct.
How many times?
Over 70 times.
I'm sorry?
Over 70 times.
70 times. Okay. And to get this accreditation, are there any other requirements that they monitor your laboratory and its employees?
Well, the CTS testing is a very important one, of course, but also when the Board of Accreditation does a visit over here, I'm not sure. In the Netherlands, that's every year. I think over here it's once every 2 years. But in the Netherlands, every year they come by and they also bring an expert, a DNA expert, a forensic DNA expert who can say and review reports. They can actually ask anything from you. So in that way, you're reviewed very thoroughly.
Are you referring to audits?
Yeah, the audit.
Okay. And how did you become involved in cases in the United States?
Well, the first case was the Tim Masters case.
Okay.
Objection to reference to specific other cases.
The counsel's on this question, his qualifications.
Sustained, you can ask him whether or not he's testified, but don't talk about a specific case and whether he's been qualified in courts over here.
Yes, sir. Mr. Eikelenboom, try and answer just my question. You were contacted from a case from the United States, correct?
That's correct.
And what kind of case would you call it?
Objection doesn't go to qualifications.
I think it does.
We approach.
Sustained, rephrase the question.
Were you sought out for your unique expertise in any?
Move to strike.
Sustained.
Were you sought out for what reason, sir?
Objection. Relevance. Could we approach, Your Honor?
Yes. You may proceed.
Thank you, Your Honor. Mr. Eikelenboom, have you been sought out to handle cases in the United States?
Objection. Objection.
Sustained.
Have you testified as an expert witness in the United States on some cases?
Yes.
Where and how many times?
State of Colorado, 2 times.
Okay. And were these by law enforcement or defense or both?
I have to correct that. It's 3 times. Twice by defense, 1 time by law enforcement.
Okay. And you now have a laboratory in Colorado?
We're setting that up.
Okay. And the training that you've received in DNA analysis, where did you receive that training?
A lot of the training was in the National Lab in the Netherlands Forensic Institute.
Okay. What kind of courses?
All kinds of courses. It's a laboratory training. It's about interpretation, analysis, statistics, mood courts. So the whole field.
Would it be fair to say from the actual recovery of a collection of evidence all the way through the statistics of being able to interpret results you've received training on?
To the court, yes. So statistics
actually even through the court. Okay. And was this accredited training?
Well, I think it's part of the accreditation procedure. If the training itself is accredited, I don't know.
Okay. And did you also have experience in all different aspects of DNA analysis?
Yeah, maybe I should explain that the reporting officer, I was in training for reporting officer. And then you, of course, have to know everything about the topics about DNA, which you have to testify in court. In the Netherlands, because the laboratory or the biology department became so big, it was separated. So you did not, as a reporting officer, you don't have to work at DNA extraction or DNA analysis. You, in this stage, they have reporting officers which have never been in the lab, I think. So to become a reporting officer, you have a different training than if you only do trace recovery or you only do DNA extraction. That is done more by lab techs. So the difference was that I went from trace recovery to become a coordinator and to become a reporting officer.
Okay. So is it fair to say you've received training on all aspects of DNA?
Absolutely.
Okay. And that you have over 20 years experience on being able to identify issues on all aspects of DNA?
That's correct.
and you've been certified both as an expert witness 70 times in the Netherlands and 3 times in the United States.
Yes, that's correct.
And you've been certified as an expert witness in DNA analysis.
That's correct.
At this time, Judge, I would submit Mr. Eikelenboom as an expert in DNA analysis.
Say we maintain its objection.
Witness would be accepted as an expert witness in DNA analysis.
Judge, would this be a good time to break for lunch?
It would be a good time, Mr. Baez. Okay. Ladies and gentlemen, jury, we're going to recess for lunch. I'm going to ask that you return here at 1:30. Do not discuss this case among yourselves nor with anyone else. Thank you. Okay, Mr. Baez, you said you had another issue you wanted to raise?
Yes, sir.
Sir, you may stand down. You can go to lunch. Be back by 1:25.
Sir, Judge.
Let's get the witness out. Make sure your staff tells him what time he needs to get back.
I don't know.
You may proceed, Mr. Baez.
Your Honor, we were given this morning, which is the date, June 21st, 2011, some discovery that was provided to us by the state. In reviewing just a crude, rough peruse of what was given to us, it appears that many of the documents that were turned over were items that have just recently come up, and certainly beyond the state's control as to being able to turn the items over, with the exception of one compact disc. This has to deal with some material from the desktop computer from the Anthony home, specifically ones that were taken from June 16, 2008. This report was completed on April 26th of 2008, but yet not turned over to us for 2 months later, after the time that the state's experts have already testified, computer experts, that is, specifically. In reviewing this also, I also noticed some photographs that appear to be some internet searches for what would be considered, and this is just one example. It's not the brunt of our objection and issue, but it appears that there are photos of shot girls, which may have been at one time viewed on the Anthony home computer. I found this particularly interesting because during Mr. George's direct examination, he on multiple occasions referred to Miss Anthony organizing or trying to collect or give advice on the clothing that the shot girls should wear, which also leads me to believe that the state had prior notice of this discovery, and that's the point why I bring that up. This is the law enforcement had this computer since July 16th of 2008, going on 3 years now, and this report after is now given to us subsequent to the state's experts already testifying. We would object to any presentation having to relate to these items, and I'm specifically referring to the computer items, not to what was disclosed previously, or what was disclosed of recent events that don't appear to be relevant to this case, unless of course they do become relevant at some time. But we would certainly object to that, and I guess I ask for a Richardson hearing on the matter, unless the state does not intend on using this newly found, well, not so newly found evidence.
Ms. Burdick?
Thank you, Your Honor. The first several items on the notice of discovery deal with a brief investigation that was conducted at the end of last week. Apparently, a citizen called the Orange County Sheriff's Office, left some information about an inmate who may have had contact with Ms. Anthony at a point in time when the inmate was in the Orange County Jail. That matter was investigated Thursday or Friday of last week. The report was generated. A statement was taken over the phone from this witness. That transcript was produced immediately. I received all of that information yesterday.
What was the name of the witness?
The name of the witness is April Whalen. Apparently, her child died in a swimming pool and was found by the child's grandfather, who immediately administered CPR and called 911. Ms. Whalen was in an adjacent cell to Ms. Anthony for a very brief period of time. Ms. Whalen indicates to law enforcement she did not talk to Casey Anthony. However, she doesn't remember if she talked to other inmates. So at the present time, it's being explored whether or not there was indirect contact. Be that as it may, as soon as I received the reports verifying that, in fact, Ms. Whalen's son did pass away in a drowning incident, as well as the reports from law enforcement of the follow-up on the information obtained by or delivered by a concerned citizen that was provided to Mr. Baez in the event that it does become relevant in relation to the subsequent investigation or the investigation that continues. The last item that is on the notice of discovery is simply a filtered copy of items from the hard drive that Mr. Baez has had for years. My use of these items, or our use of these items actually, would be exclusively in rebuttal if Ms. Anthony or another witness were to testify about specific activity occurring on June 16th. An examination of the hard drive indicates there was substantial computer activity that would rebut a lot of what Mr. Baez said in opening statement. Therefore, even though he had this information for years himself and had a computer, more than one computer consultant during the pendency of the case, as I recall, I decided that if we are going to use a demonstrative aid during the course of our rebuttal or even Ms. Anthony's cross-examination, that we would give that to counsel. And we have done so, rather than holding it for rebuttal.
Let me ask you these questions. I take it so we're all on the same page. This is contained in notice of provision of supplemental discovery dated June 21st, 2011, which bears your signature.
It does.
And items 1 through 6 all have to do with Miss April Whalen.
They do.
And that information was provided to you by law enforcement when?
The fact that they were conducting an investigation was communicated to me last Thursday or Friday, perhaps even Saturday. I believe they worked on this over the weekend. The written reports were delivered yesterday afternoon.
And so you delivered it as soon as you became aware of it and it was ready to be delivered.
That I did.
Okay. And the last item, item 7, is just a redacted version or demonstrative aid of an item that you had previously given to the defense.
The defense had their expert actually travel to the Orange County Sheriff's Office or provide a hard drive to the Orange County Sheriff's of the HP, the desktop computer in the Anthony home over 2 years ago. And the information contained on the hard drive is, of course, voluminous. I would have expected that counsel would have concentrated on the items on the computer on June 16th. However, since we did that and would like to use some of the items on the computer as a demonstrative aid, rather than having the sanction of exclusion that was suffered as a result of not providing a PowerPoint, I provided this information at this juncture.
Now, do you plan to utilize Miss April Whalen?
Based on her statement, I would say no. However, as that information is investigated, there may be something from it that would be suitable for a rebuttal case. But at this juncture, as I've told Mr. Baez, that would be no. The court may not know. We continue to get phone call after email from concerned citizens, as I'm sure they do. We have to cull through that information to determine what are just fashion suggestions or prosecution suggestions and what is actual fact or Brady material. And we have been doing that on a regular basis. This was one of those items that was investigated. If it turns out to be something relevant at this juncture, I would say no, but it could before the end of the case.
Okay, as to items 1 through 6, Mr. Baez, any additional comments?
On those items, no.
Okay,
But I do have numerous comments on 7.
okay, let me finish 1 through 6. The court will find that this is not a discovery violation. The court will specifically find that under Rule 3.220 of the Florida Rules of Criminal Procedure, that the state has a continuing duty to disclose information that becomes available to them. And also, under the case of Brady versus Maryland, they also have that duty which they have complied with. Now, let's move to item number 7, Mr. Baez.
Yes, sir. If I understand Ms. Drainburdick's position, they gave us a copy of the hard drive, so therefore they gave us, this is a filtered version of that. And I would equate that to giving us 50 phone books and telling us pick out page 700,631. The reports issued by experts in this case, and I guess we're going to get back to your order again, issued certain opinions, laid out certain dates, laid out issues that may or may show up or may not. As it relates to this date, the only thing that was issued by an expert witness was Sandra Kahn's testimony or report that states the hours of inactivity for the times of the computer search, computer activity on that day. Not who was on, not who may or may not have been on the computer, who may or may not have been home, and what exactly, what pages came up, and so on and so forth. There's so much data that we could be referring to that it now appears that the state of Florida has decided to focus in on or use some evidence during their rebuttal case for which they had during their, before the trial even started. In addition to that, there's no way, when we retain someone, we retain someone to verify the work of the prosecution in this case. So if they're going in a different direction and they issued other reports, especially given Your Honor's admonition and order, that's the area that we asked them to focus on, of course. And after determining that we would not be in need of a computer expert, we withdrew them from the witness list. So here we are without an expert witness on our case. They have had this information.
Just a second. Okay.
They've had this information for almost 3 years. And Ms. Drainburdick's response is, we've had a copy of the hard drive, so therefore we've had the information. And that's not quite accurate, given the circumstances of how much data a computer contains.
Have you, I know you haven't had an opportunity to review it, but Ms. Burdick, what's on this disk for 61608?
Contains all of the computer activity on the desktop.
From what I can see, it's scribbly data. Some of them have photos.
Items created and accessed on the on the HP, the desktop on June 16th of 2008. Data that was available on the hard drive if they chose to filter it out themselves. Mr. Baez's opening statement focused on activity occurring in the morning hours of June 16th. The computer activity, as well as instant messages that were also sent in discovery years ago, negate that timeline.
Well, let me just simply ask this. Was information provided to the defense by the state of Florida on the computer activities on June 16th, 2008?
No, sir.
So you didn't get the hard drive?
We got the hard drive, but that's everything, Judge.
Well, but they gave you all of the information, correct?
They gave us a copy of the hard drive, which contains billions of pieces of data, and they issued reports of what opinions their experts were going to render and what information they had.
Well, let me ask you this, and
if I may clarify something else, Judge. As it relates to my opening statement, I specifically said the exact hour is unknown. So for the state to allege that this is information that would directly rebut that, again,
it would seem to me as an outsider looking in that June 16, 2008 was the last time that the victim in this case was viewed by her grandparents. It became quite evident, even though it is not evidence, that from the opening statement of the defense, that the 16th was a day of great importance, and that a so-called timeline of activities dealing with Cindy Anthony as to how she spent her day on the 16th, Lee Anthony as to how he spent his day on the 16th, George Anthony on how he spent his day on the 16th, and last but not least, how Caylee Anthony spent her day on the 16th, and whether or not what, if any, activities took place on the 16th of June, on the 15th of June, and on the 17th of June, both on 24-hour cycles, would have been at least of a minimum requirement of review. And I take it at some point you did have a computer expert, I guess, regurgitate whatever was on that computer on some of those days?
yes, sir.
And if my memory serves me correctly, didn't the state's expert talk about various entries on the 16th when his testimony? He testified to certain events, didn't he?
He did not.
No, he did some event searches for chloroform and other things on other dates.
Correct.
But all of that information came off the hard drive?
It did.
Well, if the hard drive was provided to you, then it was left up to you to decide whether or not what searches you wanted to do on that hard drive, and it was not denied access to the defense, and it was up to you to determine what days you chose to look at and what days you chose not to look at. And I'm trying to wonder, how could it be the fault of the state of Florida that you chose not to look at any particular date when you were given the entire hard drive and you all knew what dates had some relevancy to this particular case?
I can tell you that we took your order to mean that all opinions that experts intend on rendering must be in a written report, and the basis for that opinion, all of this must be turned over to the defense.
Well, tell me what someone out of the state of the defense enlighten me as to what is the expert going to tell us other than extract, because most folks are not computer savvy. Some people are, some people are not, that can go in and tell us. All they're going to do is bring it up on the screen as to what activity occurred on that particular date. Generally, computer experts, when you want to render opinions, basically render opinions about whether or not somebody has tried to hide something or somebody has tried to doctor something. And, you know, that's what they generally do. But
can I add another point, Your Honor?
Yes, sir. Remember, y'all take as much time as you want to, because we're going to start back at 1:30.
Yes, sir. The issue here as well is we're giving computer information after the state has rested. We have withdrawn our computer experts from the witness list because we expected them to testify to what was in their reports and not to new evidence that was now given to us. So if the court's even considering this, allowing them to testify, we would certainly ask to have our experts, given the opportunity for our experts to review this material and see if at all it's...
They can look at it, but it's not new evidence. I don't know how something can be new evidence when it was given to you. Now, what you choose to do with it after you get it is your business, but it's not new evidence.
Well, I disagree, but we can argue that issue at a later time, Judge.
Okay.
I would like more time to review the material, give it to our experts, and then
You're free to do that.
see if we have further points to make.
Okay. Anything else y'all would like to discuss?
Nothing further.
Okay, see you at 1:30.